A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025, motion number 6, states motion, alternative perpetrators theory.
All right, that leaves in category A by my score sheet, the alternative perpetrator evidence, which is a state's motion in limine.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why do you stick that one in there?
I just forgot it.
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do that.
So for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
April 9th, motion number 6, defense's response to the alternative perpetrators theory.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person, rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial, since you're here to take care of that.
Thank you, Your Honor.
All right. And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the art of the craft involved. But this relates more to allegations of somebody more specific, identifiable.